All right, this is the People versus Christopher Moore. I have misdemeanor files 241722, 24.
Right off the bat, this isn't just one case, it's a stack of charges. Multiple misdemeanors plus a felony already signals this is going to be serious. When courts bundle cases like this, it usually means a pattern of behavior, not a one-time mistake. Keep that in mind as this unfolds.
Call as a city case that's set for pre-trial 5th and request would wait for reading and stand.
Okay, so as to 241796FY,
here's where things escalate fast. A home invasion combined with domestic violence isn't minor. Even in the third degree, this implies unlawful entry into someone's home tied to a personal relationship. That combination carries serious weight in bond decisions later.
During any future questioning and any future court hearings. In the event you can't afford an attorney, one will be appointed to represent you. You have 2 court dates within the next 21 days. Your first court date is your probable cause conference, which you can appear at via Zoom, and that is set for August 26th of 2024. Following that, on September 9th of 2024, you will have your preliminary examination. At that
this is a key stage most people misunderstand. A preliminary exam isn't about guilt, it's about whether there's enough evidence to move forward. The bar is much lower than a trial. So the real question is, based on what we're about to hear, does this easily clear the threshold?
6, State of Michigan versus Christopher Moore on 241589, and then we have a City of Taylor case 241722, and that's the B&E. As to all of those, the warrants have been set aside. They'll be set for pre-trials.
Judge, I would note that Moynihan is on. I would just ask that the 2 misdemeanor state cases be set for the 26th as well.
The misdemeanor state case be set for the 26th, so that's a Monday.
That's the same day you set for the PCC.
Oh, okay, so we'll just have them all.
Same parties.
All right.
Then the state or the city case, I think, is September 5th, if I'm not mistaken.
Yeah, there's a date of September 5th on that one. And then Ms. Moynihan, all 3 of the felony matters, then when we come in for the the probable cause conference on August 26th, we'll just have those 2 misdemeanor files follow the felony. Now, as to bond. Ms. Moynihan, is there anything you have to say as to bond?
Yes, Your Honor. Thank you. Tina Moynihan on behalf of the people, P84-692. Judge, we were in court on Monday. I was there as a prosecutor covering the docket for Ms. Sob and Ms. Davidova, and Mr. Moore was supposed to appear for an arraignment. He did appear by Zoom momentarily and then disappeared. He would not speak with Mr. Gizicki. With my understanding, Mr. Gizicki attempted to have conversations to proceed with the arraignment. And then Mr. Moore decided to log.
And this is where everything changes. Missing court is already bad, but allegedly threatening the courthouse? That moves this from a routine bond hearing into a public safety concern. Judges take threats to the court extremely seriously, and it almost always leads to harsher conditions.
Complainant who appeared by Zoom that there was an incident in the night prior, which would have been Sunday night. In that incident, Judge, there has been a warrant requested. I am in the process of reviewing that this morning. The allegations there are that the defendant broke into the complainant's home again overnight, forced his way into the home. He then adjusted cameras throughout the home that the complainant had so that he could not be observed. He's seen wearing all black, a hoodie, as well as a mask covering a portion of his face. He then enters the...
These allegations are intense. We're talking about a repeated break-in, disguises, camera manipulation, and even displaying a firearm. If proven, this paints a picture of planning and escalation, which is exactly what judges look at when deciding if someone is a danger to the community.
And heading out in an unknown direction. My understanding is that he's been staying across the street at the home across the street from her residence, And I believe that that is also going to be considered a violation of his bond that's been issued, that he's had no contact with the complainant, that he's not returned to that residence. And then there's allegations of new criminal activity. In addition, Judge, to his failure to stay in court until the case was called on Monday, I do believe that Mr. Moore is a danger to the complainant as well as to the public as a whole. He shows a wholesome inability to comply with the court's orders. I would be asking for a $250,000 cash surety bond, no 10%, with a GPS tether and house arrest if he were to be released. And I would ask that there be a 2-mile radius from the complainant's residence so that he's not to return to that area.
Anything, Mr. Fanto?
Well, I guess we have allegations that I don't know that the court should take into consideration relative bond as these cases stand. However, I would note that Mr. Moore does have some serious medical issues. At least if we could mark the files medical so that Wayne County knows. He is on SSI.
Okay. I don't think there's, the things I'm to take into consideration.
At this point, the judge is connecting the dots. Prior history, failure to appear, new allegations, and threats. This is exactly how courts build the argument for high bond. So here's the big question. Based on everything presented so far, do you think any judge would risk setting a low bond in this situation?
Criminal convictions. He clearly does not have any issue ignoring court orders. He is certainly a danger to Miss Butcher as well as the community at large. He's certainly a flight risk. He was already in immediate warrant status on one of the domestic violence charges on August 5th when he failed to appear for court. We've had a separate case where he had an immediate bench warrant on 2 different dates, both June 13 and August 5th, for failing to appear at court. He's now got pending against 1 complaining witness, 2 domestic violence cases, 3 domestic violence cases, a B&E and a home invasion. There's an allegation that a firearm was used in one of those instances. There was a police report filed. Detectives had to come over to the court Monday after there were allegations that Mr. Moore called the court, was extremely volatile with court staff. And Ms. Moynihan, the language was that he was going to come up to the court and commit a massacre. That's the allegation of what he was screaming at court staff. So I have to agree with you entirely. Mr. Moore is a danger to the community. Mr. Moore is a flight risk. Mr. Moore has shown absolutely zero respect for the criminal justice system, the legal system, or the safety of his own child that resides with Ms. Butcher. He will have a $250,000 cash or surety bond with a GPS tether with a 2-mile radius of complaining witnesses home. The file will be marked medical. Mr. Moore, you're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You're to have no contact with Miss Butcher. And a matter of fact, you can't not only go to her home, you can't go on her street. These are on the felony case. These are the bond conditions set for 1796 FY. You are not to possess or have access to firearms. You cannot purchase or access or consume alcohol or illegal drugs. On misdemeanor, I've also signed the request for a court-appointed attorney to ensure that Mr. Moore has counsel at all future proceedings, and that's in the file. As to the 3 misdemeanor files, each of these files will have a $10,000.
And there it is. A massive bond with strict conditions. This isn't just about ensuring he shows up to court anymore, it's about controlling risk. When bond climbs this high, it reflects how seriously the court views both the allegations and the behavior surrounding the case.
If I can say something when you are done, please just let me know.
Mr. Moore,
Mr. Moore, you have
prefer you not.
Yeah, Mr. Moore, you have a constitutional right to remain silent. Given the amount of hot water you're in right now, I would strongly encourage you to follow the advice of your counsel.
We've got pretrial services relative to the felony.
I will request a DSU report at counsel's request on the felony. Is there anything else?
Yes, can I say one thing, please?
Mr. Moore, your attorney is advising you not to say a thing.
I understand that. I'm asking, please. Would that be okay?
I would prefer you not, Mr. Moore.
I understand, I respect that, but this is my life in the balance and me ever seeing my kid. So I would like to say something. I understand what this looks like. I understand that you guys are upset. I understand that I didn't show up and advise to every court ruling because I've had bad experience with the judicial system. That's not an excuse, but at the same time, it is the truth of what I'm saying. I have documentation showing, and I've called the courts. I called the detective. I called the domestic violence. I recorded them. And,
Mr. Moore, listen. Mr. Moore, I
understand.
appreciate all of that. I want to be clear, given your history at this court and what's happened recently, there is absolutely nothing that you can say that will change my bond on this case. Nothing.
How about her conspiring to commit murder on me?
So
and I haven't
what will
it?
happen is your attorney has requested a DSU, and I've granted that DSU request. So the Michigan Department of Corrections will meet with you, and if they find a bond modification is appropriate, they will issue a recommendation to this court. I'm not so inclined, or I don't know that I would even necessarily follow their recommendation, but I will certainly look at it and take it into consideration. And I marked the file medical.
Thank you.
She don't have
All right.
She's going to a 1% of motorcycle club.
All right, thank you. We're all set. Thank you over at the jail.
Thank you.
Thank you.